Welcome to Employee Benefit Plans and Business Sense.
Hey everybody, welcome back to an all-new episode of Employee Benefit Plans and Business Sense with Lank and Kathleen Salas of KLB Benefits Law Group. I'm your host, Mike Leon. You know, Don and Kathleen here, they've been helping employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. They've got decades of combined experience in employee benefits law. They guide clients through compliance matters, corrections, IRS and DOL audits. I don't know what any of that means, but they're going to explain it all in just a second. In today's episode, we're going to be talking about what happens when the IRS audits a retirement plan. We're going to walk through what triggers this, what happens next, and how the right legal guidance can make a stressful process much smoother. Ladies, good to see you as always. Dahl, let's start with you. What triggers an audit of this retirement plan?
Thank you for having me, Mike. What no one knows what triggers an audit. Technically, the IRS never divulges that. Sometimes it's obvious to a plan provider, a plan sponsor, that's the employer, what triggered an audit because of what the IRS is focusing on. But it's always after the fact that you know this. That you can even guess, right? Before, as you file your informational tax return for your plan every year, that's Form 5500. You have no idea whether you will be on a short list for an audit. And that is the main vehicle of communication between the plan sponsor, the employer, and the IRS is the Form 5500. That is, as you can imagine, they're filed electronically and they're stored in a database that combs through all of the data of all these different fields that are provided in this very lengthy form. The Form 5500 provides all of the financial data and some key compliance data for the plan. So that body of information that's filed every year, there's certain deadlines, is stored in the IRS database, and they comb it presumably for red flags and things that would require further scrutiny. So, and we know this. I mean, the IRS talks about that fact that of course they're using that data to determine whether there's something that seems amiss that requires further inquiry. Having said that, the IRS does not have the manpower to audit all of the plans that have some kind of red flag. What they tend to do is they seem to prioritize the seriousness of the red flag, so to speak, and prepare correspondence for the employer where some correspondence is automatically sent out. That's not an audit. That's just a correspondence, a letter to the employer asking a question about some compliance concern. For example, we noticed you didn't file your 5500 this year, that kind of thing. An automated notice will go out to the employer from the IRS about that. And it gives the employer a chance to file the 5500 or explain why they didn't, or explain that they did file it and they can't understand why the IRS can't find it, that sort of thing. But a full-blown audit where an examiner from the IRS contacts the plan that and goes into a months long process of reviewing plan compliance, that kind of audit, which is the scary prospect for the employer, will be triggered by various things that include serious, substantial discrepancies or evidence of compliance problems with plan money. In particular, if accounts don't seem that they're not reconciling properly, or there's inconsistencies from year to year on plan assets, the type of assets, the amount of assets, there's various things that can trigger a concern in the IRS that a plan is being mishandled. So that's what the audits are all about.
Yeah, and I would just add to what Dahl describes is the most common thing. For bigger plans that have to file an independent audit with their 5500, there might be issues that wouldn't be, visible on just a typical 5500 form. But when, there could be mistakes, failures that did or did not get corrected, And the independent auditor sees that, and they're going to put notes to the financials that get filed with the 5,500. So those have to be kind of, I don't know whether there is some sort of AI that would sort of read those and flag them, but clearly if any review is done of the financials, that note would stick out and could trigger an IRS audit. Also, if they're a lot of times it's in the context of the DOL where a disgruntled employee calls the DOL hotline to report something that they think is going on wrong with the retirement plan. But then the DOL can also refer things to the IRS. So, and these are things that the employer is not necessarily going to, in this last case, the employer is not really going to know that this is going on. So it's, it's not going to be something they can kind of protect against. If it's going to happen, it's going to happen.
Right. Department of Labor out there, DOL, for folks out there that don't know the acronym. Let me ask you, because I want to use the word trigger. You guys just used the word trigger. It triggered a bunch of response questions I want to ask. So now the employer gets notified of the audit, right? And now you mentioned a little bit of this lengthy process. So they get notified. What should they first do? And what can they expect of this audit?
The very first thing they should do is engage ERISA counsel to represent them before the IRS. That's the most effective cost savings tool that they have in the event that they receive a letter. The audit will be commenced by a formal written letter delivered to the address of the employer with a deadline for response, and it usually contains a list of, it's called an information and document request, an IDR is what we call it for short. The IDR will contain requests for obvious things like a copy of the signed plan document and certain plan records going back usually 3 years, the current year and the prior 2 plan years. That's the typical scope of a typical audit. So the employer is faced with, suddenly the IRS has eyes on them for the past 3 years of plan records and transactions and compliance, and they have a deadline to reply. And they get a 2 or 3 page letter with a list of things. And it can induce panic in the employer. What it should simply motivate them to do is hire ERISA counsel to advise them on and represent them and communicate on their behalf with the IRS in connection with the audit. Hiring an attorney is always an expensive thing to do, but it's very cost effective because the IRS audits usually start much more broadly scoped than they need to be, and they have this kind of boilerplate beginning place where they cast a wide net and look for issues, perhaps, or they assume that they don't know what they don't know, so they ask a lot of questions and they look for it just to see what the employer will provide. But in many cases, the request, the attorney can assist. For example, you can immediately ask for an extension of time to reply. I've never been denied. I've represented plans before the IRS many times, and I've never been denied an opportunity to extend the deadline to reply. It seems to be a rather short deadline to reply, and it makes sense to the agent understands that the company needs time to respond. The IRS agents usually really like having an attorney involved because they know they understand that person will filter and translate their communications to the client. They don't have to explain too much to the client then if they're represented by counsel. The IRS is more comfortable, I think, in that scenario. And the most important thing one of the most important things an ERISA attorney can assist with is keeping the client, the employer contact, from saying too much to the IRS agent. A friendly IRS agent can have a person talking and get them to reveal things that are not asked for in the audit initially. But once a person starts providing facts to the agent, there's no reason for the agent not to follow up on what's being said. So an unwitting employer can inadvertently broaden the scope of the audit by blabbing happily to a sympathetic IRS agent. Not that the IRS agent's trying to trick anybody, but they're nice people, and people I think employers might be tempted to relax and start sharing. No, don't do that. You need your ERISA counsel to keep the audit lean and focused, and moving along, and hopefully not finding too many compliance problems that will require correction.
Yeah, and I would also just want to clarify, like when Dahl says the current year and the previous and the subsequent years, sometimes these audits are for the year that's being examined could be years ago. It's not necessarily, like the most recently filed 5,500. It could be 3 years ago. So it might be sometimes difficult to get records that far back, and it's really important, as Dahl said, is, we don't want an employer giving more information than what's being asked for. And that's one thing that we do is we look at the documents that the employer compiles in response, and we narrow it down to just what's being asked for, and making sure, pushing back on certain things that, may not be needed, or need some explanation, and also we're a buffer, so it not only does it are we able to be like the gateway, the guardian of the gateway to the IRS and what information goes there, but we take that stress off of the employer. They don't end up having to be, in these conferences with the IRS. We can do that in their stead. So
there is a requirement. Almost every audit, I believe every single audit that's a true full-blown audit of a plan will include a formal interview of an employer contact, of a person inside the company, to answer questions, the responsible party. In a small company, it'll be the CEO or the CFO or somebody. In a larger company, it might be a director of HR, for example. But the ERISA counsel can't keep that from happening. There is an interview, but we can coach and prepare the person for the interview, so
and
that
also,
they answer questions that are asked only, and don't volunteer information, things that would be helpful to keep the audit as narrow as possible.
And I just want to add that I've found also that once they hire an attorney and they file with the IRS, it's called for a power of attorney, so that the attorney can act on behalf of the plan sponsor, that the reviewer is often willing to do that interview with either with the employer and the attorney, or just the attorney. And absolutely. I found that, that's the goal, is to maybe just keep it to just the attorney doing the interview, and then, following up, like if there's things that the attorney doesn't know factually, they say, oh, yeah, we'll get back to you with answers on that. And usually that's fine too. So again, we're sort of shielding the employer from the stress of having to deal with all of this. And we're also trying to make it less painful by keeping, guardrails on it.
How can employers, advice-wise now, Dahl, I'll turn to you first. How can employers prepare before an audit even begins to make the process a lot easier?
Once they get notice, you mean, or just generally? I mean, everybody's on notice, right? That you could get audited, right? But if you got a letter that an audit is happening, you pick up the phone, contact ERISA counsel, engage them, and follow their advice. And their advice will be, don't just sort of, we can get through this. We'll know that you can get an extension of time. So all of that pressure of getting a notice with something like 21 days to respond might freak you out, but it doesn't have to. So the preparing can be sort of step back and know that there are experts who can help you, and this doesn't have to be horrible. And then the next way to prepare is to set your expectations to actually lean into it and be cooperative, and what's the word? to be prepared to actually deal with the audit. If it's all, sort of psychologically, I think, to prepare that this is going to happen, you have to answer questions, address any compliance issues that come up, patiently interact with your professionals, not just your ERISA attorney, but your TPA is going to have something to say about records, and your the financial custodian of the plan accounts is going to have input, and the or at least data, and maybe your investment advisor and other people. You would, and if you have a plan committee, that group in house can share the agony with you, so that you're not, you can commiserate a little bit. But I would say preparing is putting people on notice, your professionals and your in-house team on notice that this is happening. Understand that you will get help. You can get help to do it, to deal with the audit, and that you really do need to process all the different steps of actually going through the audit. You can't argue it away. It will happen. And if you have compliance failures that you're aware of as you go into the audit, some of them can be fixed even during an audit. Some minor compliance failures can be self-corrected even during an audit. And that's great. So you just share with your professionals what you know, and share with your ERISA counsel what's happening, and get everybody on the same page to work together through the thing. But I think it's the concept is take a breath and prepare psychologically for this process, because it takes time and it's uncomfortable.
And I would also just add, sort of from a real practical standpoint, start gathering the documents in that IDR. Because employers may not have all of that information in their own file, so they need to go talk to all those vendors that Dahl just mentioned. Get their make sure they have signed copies of their plan documents. Make sure that they get certain statements and filings and census. Then usually they'll ask for an employee census for the year under examination. Just start looking in their own files and checking, where they don't have things, they can check with their vendors to get that information. And also, as Dahl mentioned, certain things can be self-corrected if they're, small, sort of insignificant failures. But I think, if there are, it's good to know that if there are bigger failures that aren't eligible for the self-correction, it's important to know they can't be corrected. You're now under audit, and those have to be only corrected under audit, which means a sanction and things like that. So it's just good to know what you're dealing with going into the whole process, and that might include some failures that need to be corrected.
Right. As we wrap here, ladies, I'll turn to each of you. Dahl, I'll start with you first. What is one thing, just one thing, you want plan sponsors to remember if they ever face an IRS audit? What's that one thing? Dahl, you first.
To call an ERISA attorney first.
Yeah, there we go. Kathleen?
Stole mine.
Well, give me another one, Kathleen.
Okay. Well, the other one is don't talk to the IRS without that benefits attorney. Don't talk to them. Don't send them any information. Get your professional in place and let them deal with it. So, don't, a lot of people think, I can talk to them and I'll, no.
Yes. No. I've seen, and also I've very cooperative service providers will often just produce documentation in response to the IDR that is way too much information, and really even more than's being requested. And it does a disservice. It's unintentional. I mean, of course they're trying to be helpful, but it can do a disservice to the employer by giving the IRS a lot of ammunition for a lot of grist for the mill, to find failures, operational failures and things. So.
Yeah. Ladies, thank you as always for the time and insights on this. We truly appreciate it.
Thank you, Mike.
Thank you.
And thank you to everybody out there for listening to this installment of Employee Benefit Plans and Business Sense. If your company has received an IRS audit notice right now, you heard the ladies what they said. If you'd like to make sure your plan is ready before any of that happens, do me a favor, visit klblawgroup.com and connect with Dahl and Kathleen and the team, Be sure to like, subscribe, leave us a review and comment, or share this episode with someone who needs this information. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.